Hello and welcome to this seminar, the first in the seminars organised by the Oxford Children's Rights Network in collaboration with the Bonavera Institute for Human Rights. We're very grateful for them to be hosting us today. Really only one piece of housekeeping, because we're able to ensure that you're all on mute anyway, so we won't have any sound disruption. After Alice has spoken, we very much hope that you'll have questions, and we ask, given that there's quite a few attendees, if you could type them in the Q&A box, which you'll find at the bottom of your screen next to record, rather than typing them in the chat box, simply because that makes it easier to organise. I'm also delighted to introduce Vania Pinto, who is also on the committee for the Oxford Children's Rights Network. So we have, we're again delighted to welcome Alice Irving today, who is a barrister at Doughty Street. Before that, Alice did her doctorate at Oxford, which she completed in 2019 in criminal law. And since joining Doughty Street, she's had an impressively broad public law practice, covering discrimination law, welfare, housing, and also the law relating to children and disabilities. And it's those last two topics she's going to be talking to us today, with, I think we all agree, particularly at the moment, a very relevant seminar on the rights of children with special educational needs and disabilities during the pandemic. So I hand over to Alice.
Great, thank you so much, Charlotte, and thank you for the introduction and the chance to speak here today. I'm going to cover, hopefully in the time, a very brief thumbnail sketch of the law as it relates to children with special educational needs and disabilities, particularly what we call education, health and care plans. And you'll have to forgive me if it's a mixed audience and some of you are already very much up to speed on this. That nevertheless, I'm going to do a whirlwind tour of that framework before I set out some of the changes that were made by the government to the legal obligations owed to children with SEND in response to the pandemic. Once I've set out the changes that were made by the government, I'll talk a little bit about the evidence of the impact that actually had on the ground. And then finally, I'll discuss a case that I was involved in as a junior barrister, where we tried to challenge the government's changes to the legal rights of children with SEND during the pandemic, unfortunately unsuccessfully, although we've applied for permission to appeal. Once I've made my way through that, if there's time, I will talk briefly about some of the ongoing difficulties faced by families and children with SEND, in particular in terms of returning to school and the decision making around that. So without further ado, if I can get my slides to work. So as you may already know, the Children and Families Act 2014 introduced a really important change in the field of the rights of children with disability and young people as well. And this was the introduction of what we call education, health and care plans. These replaced previously what had been called statements of special educational need. And effectively, an education, health and care plan is put in place in relation to children where it's determined that that's necessary for their special educational provision to be made. Effectively, what this means in practice is where a local authority assesses an individual and determines that their needs can't reasonably be met within sort of the provision provided by a normal mainstream school. So the Children and Families Act 2014 is really the core of the new regime as it relates to children with special educational needs and disabilities. And you'll see also their reference to the special educational need and disability regulations, which flesh that regime out further, and the SEND Code of Practice, which is statutory guidance as to how the regime is to work. So very brief whistle-stop tour. So if a child is assessed or a young person is assessed as being in need of an education, health and care plan by a local authority, that is that their special educational needs can't be met through the normal provision of a mainstream school, then a local authority must issue an education, health and care plan for that child. And the regulations set out specifically what that plan must include in these various sections. And so you see them listed there. Now, generally speaking, the most significant sections are sections B, which set out what the child or young person's special educational needs are. And that's determined with input from expert reports, generally from educational psychologists, speech and language therapists, occupational therapists, and so on. And then section F, which flows from section B. So once you've identified the special educational needs of a child, section F sets out the provision which it's determined is required by the child to meet those special educational needs. So this isn't what would be a bonus, or it wouldn't be what would be Rolls-Royce provision, but instead what everybody agrees is required in order to meet those base needs of the child. And then section I is generally really significant as well, because that's the placement. So section I will either state the name of a particular school or institution, or if there's not a particular named school or placement, it might say the type. So it might say a mainstream setting, or it might say a special educational provision, or it might say a residential placement. You'll see also that an education, health and care plan covers healthcare provision and social care provision. That's limited to the extent that those are types of health and social care provision that are sort of connected in with the special educational needs of the child. And I think the rest is self-explanatory except for section J, which relates to direct payments. So that simply means that sometimes a family will prefer to receive direct payments from a local authority to enable them to arrange some of the provision themselves. And section J will have that content set out. So as I say, this is a bit of a whistle-stop tour. But if a child or young person has an education, health and care plan, it will have all of these sections with content populating those sections. Now, why is this significant? Basically, if you can manage to get an education, health and care plan, that generates very specific legal duties. So most importantly, and kind of the heart of the whole system, is section 42 of the Children and Families Act. And this provides that if a local authority has put in place an education, health and care plan, then they're under a duty, they must secure their special educational provision that's set out in section F of that plan. So that's a blunt obligation with no exception. Similarly, if there's healthcare provision in that plan, then local commissioning body, likely to be a CCG, clinical commissioning group, must also arrange for that healthcare provision to be provided. Without descending into detail, there are separate provisions elsewhere in relation to social care provision, and I can talk about that later if anybody has any questions. Accompanying section 42 is section 43, which is effectively a duty that's placed on any school named in section I of a child's education, health and care plan to admit that child. So if a school is named in an education, health and care plan, then they have to admit the child and they can't refuse to do so. You can see that these are really important and core duties to ensuring that the special educational needs of children with often quite significant needs are met. So before I move on to sort of discuss a bit more about how that was working prior to the pandemic and then what happened when the pandemic came along, I just want to briefly as well set out a thumbnail sketch of the education, health and care plan process. So if somebody has a child or young person who, a family member, for example, or even a school, think that maybe an education, health and care plan is needed, then you can apply for a needs assessment to be carried out by a local authority. The local authority will decide whether to carry out an assessment. If they do, they will then decide whether an education, health and care plan is necessary. And if one is necessary, they'll determine the content of that plan. Once a plan is in place, there have to be, and this is a statutory requirement, annual reviews of the education, health and care plan, and that can result in amendments. And generally an annual review involves a meeting with various stakeholders, reports from the school and so forth that enable an assessment of how the child is coming relative to the outcomes that were desired and sort of set out in the plan, and whether the provision and their needs and the provision have changed over time. There's also a mechanism where parents or the young person themselves can request a reassessment if they think that the education, health and care plan is so far from what is appropriate that things need to sort of start from scratch. In addition, the local authority can take a decision to cease an education, health and care plan if they consider that it's no longer necessary. You'll see why I'm bothering with this kind of detail in due course. All of these processes are subject to timescales that are set out in the SEND regulations, and these are specific timescales. So you have X number of weeks within which to carry out an assessment. You have X number of weeks in which to communicate a decision. And any of those decisions, whether it be a decision not to carry out an assessment, or a decision not to issue a care plan, or a decision to issue a plan, but the contents of things that the parent doesn't agree with, all of those decisions are going to be subject to appeal to the first tier tribunal. And that's provided for in the legislation. So that's a really important remedy. And there is a lot of dispute generally between parents and local authorities about what should be in a plan, particularly in relation to Section B, Section F and Section I of the plan. So what a child's needs are, what the provision should be to meet those needs, and what the placement for the child should be. Those are often in dispute, and that often ends up before the tribunal. So before the pandemic, how is all of this working? Unfortunately, very, very poorly. So I've got some excerpts from some key reports or sources in relation to the SEND system. And you see that in 2019, the local government ombudsman, who can receive complaints about SEND provision by local authorities, published what he called a focus report, which was a specific report prepared in recognition of the fact that something was awry in the SEND system. And you'll see there the quote that the local government ombudsman was upholding almost 90% of investigations or complaints made by parents, which is far above the ordinary average, and effectively that the system was in crisis. Similarly, there's an inspection regime where Ofsted and the Care Quality Commission inspect local authority provision of SEND. And they've been doing that since May 2016. And as of March 2019, of all of those places that had been inspected, local authority areas, and who had received an outcome from that inspection, almost half of them had been so poor in their performance that that Ofsted and CQC had imposed the most serious sanction, which was to require them to submit a written statement of action. So again, this suggests significant and widespread failings. Similarly, there was a select committee report in 2019, again, finding that there is, I won't read all of that out, I'll let you take a moment, but finding that although the 2014 reforms in idea were very good, that basically they're not working on the ground, largely because of poor administration and low funding, and that a lot of families are therefore being let down. Unfortunately, on the coalface, I work in education law, and I do a lot of work with families, with children with special educational needs who are fighting local authorities for provision. What this looks like is pretty dire. So you have children who have education, health and care plans that say they need X, Y, and Z, and that hasn't been provided for years on end in some cases. And this is really, clients where their children are partially sighted and they have absolutely no support to develop independence over a number of years, or children with speech difficulties who had no speech and language input despite that being stipulated in their plans. Similarly, it's fairly common for there to be really significant delays. So there's meant to be an annual review, it's not carried out, or when it is carried out, it's carried out very, very late. What comes out of that is often poor quality, which requires recourse to the tribunal, and effectively most of the families I work with have been fighting for years on end with their local authorities just to try to get in place what their children should be entitled to. So it's a fairly dire picture, and that was the case before the pandemic even began. So when the pandemic hit and it became apparent that this was going to have a major impact on the country, and particularly on education, two things happened of significance in the education, care and plan context. The first was that the Coronavirus Act, which has kind of a grab bag of powers conferred on the government, and I'm sure that you've heard a lot about all the various things that legislation kind of conferred on the government to do, but one of them was it empowered the Secretary of State for Education to make notices that could last for up to a month. And the effect of a notice would be to downgrade that core duty in Section 42 of the Children and Families Act. Now, if you recall, that was the duty that said if an education, health and care plan specifies either special educational provision or health provision, then the local authority or the local clinical commissioning group must make sure that educational or health provision is in place. The notices, when enforced, changed that so that the duty would be treated as discharged as long as the local authority or the clinical commissioning group used reasonable endeavours to discharge the duty. And the Secretary of State did make 3 notices that downgraded Section 42 in this way, and they were in relation to May, June and July. So for any of you who have any kind of feel for public law, you'll immediately see the difficulty here for any parent who might seek to challenge a local authority for failing to secure provision. Prior to these changes, if a local authority didn't provide educational provision that was set out in a child's education, health and care plan, was a fairly straightforward legal challenge. So I've got a JR at the moment where the local authority just hasn't provided what's set out in Section F of the Education, Health and Care Plan. We simply JR saying you've breached a statutory duty. It's very straightforward. When this was enforced and the notices downgraded the duty, as long as a local authority could show they'd used reasonable endeavours, then that would be sufficient for them to discharge their legal obligation. And effectively, the feel amongst lawyers in the area was it would be very, very difficult to convince a court that there'd been a failure to use reasonable endeavours. Obviously, it left a lot in the hands of the local authority in terms of what would be reasonable. There was a huge amount of discretion, and that would be very difficult to challenge. And so the concern was that parents would be left without an effective enforceable right against local authorities should local authorities cease to make adequate provision for their children during the pandemic. Excuse me. The second change that was made was in relation to the timescales that I somewhat dryly set out before. So previously I mentioned that the SEND Regulations 2014 set out a series of fairly strict timeframes in relation to, for example, how quickly you have to turn around a report after an annual review, how quickly you need to decide if somebody should have an education, health and care plan, and so forth, and also how quickly a local authority has to comply with an order of the first tier tribunal if the tribunal finds for the family following a hearing. Those timescales went from being fairly rigid to, again, being relaxed. So if it was not reasonably practicable for a specified time frame to be met because of the coronavirus pandemic, then it would only be necessary for a local authority to take the step in question as soon as reasonably practical. And again, we get this language of what's reasonable, and the same concern that this is very amorphous places a lot of power in the hands of the local authority, and effectively means that it's very, very difficult, if not impossible, for anybody to hold a local authority to account for delays in the EHC plan process. And the significance of that, it's not just sort of procedural, is this: if a child doesn't yet have a plan in place and there's delay in putting one in place, or if a child does have a plan but it's out of date and needs updating, all of those delays mean that there's a period of time where that child is not receiving provision that's appropriate for them, or maybe not receiving any provision at all. So this is of real practical impact on the ground as well. So those regulations came into force on the 1st of May, and they expired on the 25th of September. So what was the effect of these changes? So the Children's Commissioner came out fairly firmly early on after these changes were introduced, saying that she considered them to be disproportionate, and highlighting that, again, leaving it in the hands of local authorities to determine what was reasonable would likely lead to further difficulties in SEND provision. Similarly, 50 sector organisations, including Contact, the the Council for Disabled Children, the National Autism Society, and many others, wrote a letter setting out that they were already receiving communications from parents saying that some local authorities were making little or no attempt to engage to agree what provision could continue. So we saw a cliff edge in some places. So it was really quite patchy. Some local authorities did their best to continue to make provision. Others just completely stopped and cited the legal changes as a basis for doing that. You also had instances where delays that had existed in the system, or failings that had pre-existed the pandemic, so a local authority hadn't taken the steps that they should have taken within time, or hadn't made provision prior to the pandemic suddenly were claiming that the pandemic was the reason for that failing. So real concern about the impact of these legal changes on what was happening on the ground. Similarly, the Disabled Children's Partnership carried out a survey of around 4,000 UK families with disabled children in May 2020. And you can see there were some pretty stark findings there about the level of withdrawal of support, including crucial therapies for children. And I think it's worth recognising that for some children, a period of removal of, for example, speech and language therapy or some occupational therapy or physio could have really significant impact. So could lead to progress that had been made being lost, and in some instances, long-term impact on that child's ability to reach their potential. So this was really serious, and we were hearing a lot of very concerning things that were going on. So two parents acting as litigation friends for two young people with education, health and care plans very bravely acted as claimants in a challenge to the Secretary of State for Education. So Amber Shaw, who wasn't anonymised, who's a young woman with special educational needs, and another young client who was anonymised, brought the claim. I was involved in the claim as junior counsel, led by another barrister who's at 39 Essex named Steve Broach. I do have to be a bit careful about what I say because we have applied to appeal from the outcome of this case. But nevertheless, I can give you an overview of effectively what the case entailed and what happened. So we ran 5 grounds, and the case was fairly complicated for a number of reasons. One was that we were challenging a number of different decisions. We were challenging decisions in relation to issuing 3 notices, so the May notice, the June notice, and the July notice, which were all discrete decisions because those notices downgrading the Section 42 duty could only last for 1 month at a time. And we were also challenging the decision to make the regulations amending the timescales. So there were a number of decisions in frame, and for each of those, there were slightly different considerations in play, and particularly as each of the notices were made from May to June to July, more and more information became available to the Secretary of State for Education, and the kind of complexion of things changed. So the first ground we argued was that there was a failure to consult, and particularly that there was a failure to consult with children and young people and families of children and young people with SEND who would be directly impacted by these changes. The core of the argument on this point wasn't about whether consultation had been carried out. The Secretary of State admitted that there had been no consultation. The argument was whether there was a legal duty to consult or not. If you're familiar at all with the public law in this area, you'll know that generally speaking, you might be looking for a prior practice of consultation or a legitimate expectation of consultation brought about by some kind of promise that this would happen, or a statutory obligation to consult. There wasn't any of those things in this case. And so we were left to fall back on what might be called the 4th category of consultation duty, which is to say it was conspicuously unfair not to consult these families. And we argued that it was conspicuously unfair to effectively remove a benefit to this cohort that was incredibly vulnerable, where that benefit had been in place and had endured for their benefit for a long time. And there was some case law that supported us in that proposition. We also said it was conspicuously unfair because it emerged that prior to making the decision to make these notices and the regulations, that the Secretary of State and the Department of Education had engaged quite extensively with local authorities and representatives of various local authorities who were all very concerned that they wouldn't be able to meet their legal duties during the pandemic, and who therefore might be subject to litigation, which would be distracting them from doing what they could during the pandemic. So there'd been a lot or informal engagement, I should say, with one side of the story. So those who provided support to children and young people with SEND. But there'd been very little engagement with actually the children and young people with SEND and their families themselves. And so we said that that was conspicuously unfair, and that in all of those circumstances, a duty to consult did arise. The second ground, and I'll talk about what happened in due course, it's a bit painful because perhaps you already know that we weren't successful on any of these grounds. but the second ground was that there was a breach of the Tameside duty. So the duty established in the famous Tameside case is a duty to make adequate inquiry to allow a decision maker to reach decision. And it's a fairly difficult breach to show, because you basically have to show that no rational decision maker would have thought they had enough information to make the decision that they made when they made that decision. And we had a number of different points, and this ground kind of evolved over time as the situation changed in relation to each of the different decisions that were made. So in relation to when the amendment regulations themselves and the early notices were made, we said that there was an inadequate inquiry on two grounds. So the first was a lot of the local authorities were saying to the government, we're really worried about being subjected to really unfair litigation during the pandemic because we can't discharge our duties under Section 42, we can't meet our timeframes under the regulations, and people are going to sue us, and that's going to divert resources, and that would be very bad. One aspect of we said there was an adequate inquiry was whether those fears were actually founded in anything or not. We said that the government, in order to attach weight to that consideration and deciding to make these legal changes, should have looked into whether there was actually any basis, and would have found, if they'd looked, there wasn't, because the position, as we said, it was that parents were very, very unlikely to bring claims that would have been pointless. Mostly what parents were concerned about was not, my local authority isn't providing me with something that is clearly impossible for them to provide. The kind of concerns were they're not giving us anything at all. So we just said that this was effectively lobbying on the part of local authorities, and that the government ought to have looked into it rather than accepting it at face value. The second aspect of an adequate inquiry was, we said they failed to consider or think about the impact that this would have on children and young people. In particular, they didn't consider the history of failings in the SEND system, which we've already covered and which were significant. And in that context, if they'd thought about it, they would have realised that downgrading the legal duties in this area would likely lead to even further failings of provision, and that this should have been thought about more, if at all. By the time we came to the latest notices, so by the time we came to the issuing of the July notice, the decision to issue that was taken in late June, the situation had changed somewhat. By then, there was some information before the Department of Education about the impact that these changes were having on the ground. So they knew that things had gotten fairly bad. Nevertheless, our argument was instead then focused on the briefing that was prepared for the Secretary of State, who took the decision to issue the notice. So on the one hand, we had this body of evidence about what the Department of Education knew about what was happening on the ground. And then we had this document, which was the ministerial sort of briefing document sent to the minister saying, we want you to sign off on this notice that will continue to downgrade the duty. And it set out in that briefing what the impact of that would be. And the difference between the two, we said, was quite striking. So on the one hand, you had evidence of provision sort of ceasing to be made or being severely reduced. And in the briefing, the language was very sort of general. It said things like, it may lead to some impact for some children with SEND who may receive less provision. It was all fairly weakly worded. And so we said, and there's a case authority again as to how the Tameside duty plays out where the decision maker relies on a briefing that's been prepared by someone else, that although the Department of Education had the information at that time that they needed to discharge the duty to have made adequate inquiry, the briefing that was provided to the minister was incompletely inaccurate or misleading, and therefore the decision taken on that basis couldn't stand. The third ground was fairly novel, and it related only to the amendment regulations. So the amendment regulations themselves were laid before Parliament the day before they were due to come into force. This meant that there was effectively no parliamentary scrutiny whatsoever of the regulations. And this is a pattern that's been very apparent throughout the pandemic of the government laying regulations that come into force or announcing things before even laying regulations without Parliament having a role at all in scrutinising the changes that are being made. You may have followed Lady Hale's concern about how far Parliament's been sidelined during the pandemic in scrutinising measures being taken by the government. We argued that it was irrational to do this. Now, it's a little bit frustrating. I think the judgment perhaps mischaracterizes our case slightly. So there is a convention that says that normally amendments, regulations should be laid before Parliament for 21 days before they come into force to allow a window for scrutiny. We never argued, and it wasn't our argument, that that convention was enforceable and that a breach of that convention could be a successful ground for judicial review. What we did say, though, was that there was a framework whereby if the government wanted to lay regulations within a sort of a time that's less than 21 days, they had to provide reasons for doing that, and that's set out in the sort of convention documentation around this. And we said that the reasons that they gave for having only 1 day before the regulations came into force were irrational. So there was basically no good reason for that level of curtailment of parliamentary scrutiny. There was no evidence that, for example, waiting a week would have had deleterious effects on local authorities or would have been intolerable. And given the importance of parliamentary scrutiny, the reasons given just really weren't good enough. But we had to obviously get to that high standard of the reasons being irrational. The fourth ground D, related to the notices only. So the notices downgrading section 42 of the Children and Families Act, that core duty to secure provision when it's set out in a child's education, health and care plan. One of the requirements in the Coronavirus Act, when the Secretary of State decided to make those notices, was that on the face of the notice, the Secretary of State had to explain why he considered it to be appropriate and proportionate to make the notice downgrading the duty to children with special educational needs. So ground D involved us looking at the reasoning that had been provided on the face of notice and saying that that reasoning was irrational. That was always going to be a stretch, as you imagine, but effectively there were a number of lines of argument, but a lot of them focused on the fact that the reasoning was incredibly one-sided, and when it came to the proportionality analysis in particular, that proportionality sort of by definition ought to involve the balancing of competing interests, and there was no balancing whatsoever because of the sort of myopic one-sided focus on the difficulties that local authorities might otherwise face. What was interesting as well is because we mounted this legal action before all the different notices had come into play. So when we filed, May and June were there, but July hadn't happened. Before the June notice had been issued, we had been in pre-action correspondence. So what we saw, somewhat frustratingly, was that as each of the notices were then issued, the reasoning in them got better to address some of the arguments we were raising in pre-action correspondence or having issued, although we still said the reasoning was deficient. The final ground was a breach of the duty under Section 7 of the Children and Young Persons Act. That essentially places a duty on the Secretary of State for Education to have regard to the well-being of children in exercising his functions. And we said that there wasn't evidence that there had been due regard to the well-being of children in the decision-making. It's sort of another way of framing some of the earlier points, which was that there'd been a myopic focus on concern about local authorities and a lack of inquiry as to the actual impact or the sort of the significance of these changes for children. So we got some of the way into this. We'd issued the claim, and we had sort of a listing date for a hearing. We were given what's called a rolled up hearing, which is a hearing where both permission to bring the judicial review claim and the substantive kind of grounds themselves are fully argued all in one go. And that was in recognition of the kind of need for things to be decided quickly in this arena. And then on the 2nd of July, the Secretary of State announced that he had no intention of issuing any more national notices unless the evidence changed. And on that basis, we were invited to discontinue the claim because they said the claim was now academic. The May and June notices have both expired. The July notice would expire 2 days after the hearing date had listed. We were listed at the very end of July. And therefore, at least in relation to the notices, they said the claim was academic. There was nothing live left before the court to consider. Now, this is an interesting one because this is a point that's been coming up a lot in litigation challenging government decisions in relation to the pandemic. The situation is so fast moving that often, even when you've gone through the process of getting to court very quickly, and our claim was expedited, by the time you get before the court, often new decisions have been taken that have superseded the decisions that you're challenging, and therefore arguably the claim is academic, and the general proposition is that it's a waste of court time to consider academic claims because they will have no practical effect on the ground. Our response to this was to say, no, we want to go ahead because we have, one, no assurance that the Secretary of State won't issue another national notice, because the Secretary of State says they might do so if the evidence changes. And obviously at that time, we were all aware that a second wave might come, and we're at the beginning of, or perhaps well into that now. The second point that we made was that if they were to consider making another national notice, downgrading the Section 42 duty, that our arguments about whether they ought to consult and the extent to which they had to make inquiries and so forth would be relevant and could inform the Secretary of State in taking that fresh decision. So we were saying it would be useful guidance, although for the Secretary of State in any future decision making, although the courts can be wary of providing guidance, it's not generally their role. Obviously, this argument didn't apply to the amendment regulations, which had changed the timescales in which education, health and care plan processes could be completed, because those didn't expire until September. So they were very much a live issue at the time that we hit the hearing at the end of July. But that was only one narrow aspect of the claim, and you might understand that our focus was probably largely on Section 42 because of the really core impact of the downgrading of that really important duty. Now, we don't know, and we will never know, whether the Secretary of State would have made this announcement if we hadn't litigated. Obviously, they will not admit that they decided not to issue any further notices because of the litigation, because if they admitted that, they would have to pay some of our costs. Maybe we helped this outcome to come about, but who knows? What the Secretary of State did leave open was the possibility of local notices downgrading the Section 42 duty. And this was kind of consistent with the general move within the government towards sort of a more localised approach to managing the pandemic. So we wait with interest to see if any local notices modifying Section 42 do come into force. Given the rationale for the imposition of the national notice, it seems surprising to me that they haven't issued any local notices in areas where, for example, there is a Tier 3 lockdown at the moment, because I would have thought the same reasons why they said they couldn't discharge the Section 42 duty to make provision to children would apply equally in those areas that are at the highest level of lockdown now. But as I say, we sort of hold our breath and watch, and it's a good thing as at present that we've got Section 42 fully intact and fully functioning throughout the UK. So what happened in the decision itself? We were before Mr. Justice Kerr. I've pulled out the one bit of the judgment that is sort of a happy moment of reflection, which is he did recognise that the impact of the legal changes had been significant. He did recognise that there were serious failures in delivery of SEND provision prior to the pandemic, and that the impact of these legal changes disproportionately affected children with SEND. Nevertheless, we were not successful on two of the grounds. So the consultation ground, ground A, and perhaps it would be useful to go back, the ground C, the idea that it was irrational to lay amendment regulations before Parliament the day before they came into force. We had permission granted, but we refused, we did not succeed on the substantive argument. The rest of the grounds we weren't even given permission, which was very frustrating, having spent 2 days in court arguing about things to be told that they were unarguable. Just very briefly, as I'm aware of time, a whistle-stop tour of the reasoning. On ground A, while Justice Kerr recognised that there had been an abrupt removal of a core duty, he effectively, which could lead to potentially a duty to consult, he said that it wasn't conspicuously unfair in the particular circumstances of the pandemic, that adequate inquiries effectively had been made, and that it wasn't unfair given how quickly the decisions of the government had to be taken to forego a full consultation process. So it's a very, very thumbnail sketch. You should read the judgment itself for the rationale in full. As to ground B, Justice Kerr just simply didn't accept that there was an adequate inquiry. He said that they had enough information to make the decision they did, and he didn't accept that the briefing was inaccurate or misleading. he didn't accept that it was painted an overly rosy picture compared to what was being shown to be the case in the information that the Department for Education had. Ground C was an interesting one. So there was a constitutional law argument about whether or not the court could even say anything about when a government chooses to lay regulations before Parliament. So there's a provision of an old Bill of Rights, and Article 9, that says that the court shouldn't consider proceedings in Parliament. Normally that means they can't consider the words of things said by, say, ministers in Parliament in litigation. You can't, for example, be liable for defamation. But it does extend to a certain extent to think about what role the court could have in regulating government procedure and parliamentary procedure, including the timing of laying regulations. And on that point, the court held that the court couldn't effectively criticise the government for laying regulations with the timing they did without breaching sort of that prohibition on the court getting involved in proceedings of Parliament. And even if the court could say something about that, they didn't think that the reasoning offered for giving just 1 day for parliamentary scrutiny was irrational. Ground D, the court basically said we just strongly disagreed with the reasoning in the notices, but it didn't reach the level of rationality. And ground E, the court accepted, and this is important because there was some contention around whether Section 7 even created a duty that could do any good in judicial review, whether it was enforceable in any kind of way, really, before the courts. The court did accept that Section 7 did place a duty to have almost a duty to have take into account a relevant consideration on the Secretary of State, but that had been discharged and there was sufficient evidence that they had regard to the well-being of children. So all around, it wasn't a fantastic day in court for us. Although if you've been following the litigation in relation to the pandemic, you'll see that nobody's managed to succeed in any of the challenges to any of the government decisions that I've seen go to court in relation to the pandemic. And that includes perhaps for this particular audience, you'll be interested to, if you haven't already followed, the Article 39 challenge to the kind of downgrading of a load of duties to children in care, which again was unsuccessful before the High Court, and that was brought by the charity Article 39. Now we have applied for permission to appeal to the Court of Appeal on all grounds, and we are waiting to hear. But as time goes on, and given what I said earlier about matters becoming academic, it becomes harder and harder probably to see a way through this. So that is to an extent historical, although we keep an eye out for any potential future downgrading of legal duties to children with SEND, because that aspect of the Coronavirus Act that empowers the Secretary of State to issue notices to downgrade the Section 42 duty is still in force, so the Secretary of State still has that power and may exercise it again. But aside from that, what's happening on the ground, just very, very briefly, being aware of time, right now that are sort of some of the challenges we're hearing from children and young people and their families. One of the big issues that's come up, and a lot of the questions that we're getting from the community, relates to, okay, so at the beginning of this autumn term, everybody was meant to go back to school. What does that look like for children with SEND? So there were kind of two concerns in polar opposite directions. One was the concern of families who had wanted their children to continue attending school, and most schools were meant to continue to keep places open for children with education, health and care plans, even during the kind of strictest lockdown. But schools have been saying, no, it's too risky, and we're refusing to have children come back to school. So at one end of the spectrum, you have parents who would like their children to return to school, or young people who would like themselves to return to school, but are unable to do so because a school is saying, no, we can't manage the risk. At the other end of the spectrum, we have parents who have children who are vulnerable, perhaps because of their disabilities, or perhaps because of some other underlying health need, who don't want their children to return to school, but are being effectively told now that they have to. So the current status of things is set out in the guidance for full opening of schools from the Department of Education, and it's been updated a number of times, but not a huge amount has changed. Effectively, the headline is that school attendance is mandatory, and schools should be making provision for children with SEND, which is good news for the families who want their children to go back to school, is that you do have government guidance saying everything is back to normal, in theory, which you can press a school with if they're refusing to allow a child or young person to return to that setting. I do, however, have as clients some families who are at the other end of the spectrum and don't want their child to return. And the difficulty that they're facing is that the guidance is very, very narrow in terms of when that might be seen as being justified. So the quote is there, effectively, unless you have clinical advice, which we're talking about good medical evidence, strong medical evidence, or the public health advice in the area, so basically what the rules are in the local area, say that a child can't attend school, then they must attend school. And if the child doesn't attend school, then the school can mark them as being absent without good excuse, an unexplained absence, and this can lead to potentially sanctions against the parent for failing to secure attendance. Now, schools nationwide are taking a variety of different approaches to this. Some schools are being fairly sensible where parents have concerns. They're saying, okay, we will mark this as an absence that's explained, and we'll agree to you continuing to keep the child at home or continue to provide remote education support. Other schools are saying, no, we're not going to continue to provide remote education support without good clinical evidence, perhaps evidence from a consultant or some similar. You are required to be back at school, and so your child must be sent, and if you don't send them, we have concerns about those absences. And at present, it's a fairly difficult situation for families to navigate, as you might understand, and it's a changing spectrum. There's very little actually that can be done to kind of push back on this and the current situation if you don't have good clinical evidence, and the school, which has a level of discretion as to how they deal with absences. If the school won't play ball, this is putting parents in a very difficult situation, some of whom are considering the fairly serious step of transferring to homeschooling as a result. But that is just a very brief précis tacked on the end of one of the issues that's sort of still live and that's coming up a lot in discussions that I've been party to in relation to ongoing challenges for children and their families who have special educational needs. Now, I've just spoken non-stop for a very long period of time, so I'm going to stop sharing my screen so I can see other people on the panel and throw over to Charlotte to see if there are any questions arising. I'll have a quick look in the question answer box myself.
Thank you very much indeed, Alice. I can assure you there are questions arising, which I'll try and take in order. First of all, we have a question from Naomi Webber. I may have to summarize some of these questions, Alice. You can see them in full text.
Yes.
But they're pleasantly detailed. Naomi says it was her understanding, I think you touched on this, that even when the schools closed, children with EHC plans were entitled to attend school. They were priority along with key workers' children. However, in a recent BBC Panorama programme, it was reported that many children with EHC plans were not in school during lockdown. Do you know anything about the statistics on that or the law underlying it?
Certainly. So I don't have statistics at hand, but I can explain a bit more about what was going on there. So you're correct in saying that children with EHC plans were part of the sort of priority cohort that were entitled to continue to attend school. Generally, the way that was to be operationalised, and this was the framework set out in guidance by the government, was that the school was to carry out a risk assessment of that child to determine, or the young person to determine what steps needed to be put into place and whether it was appropriate for them to attend. And that was meant to be co-produced with family and the young person themselves to find a solution and a way forward. What we heard on the ground was that very, very, very few parents were themselves actually being involved in any of the risk assessments, and were subsequently just being told by schools that their child had been risk assessed and it had been determined that it was too risky for them to attend school. There was a lot of instances of that risk assessment process, which was meant to facilitate kind of a sensible route towards ensuring that attendance was safe, being used effectively to bar attendance in relation to children with special educational needs attending school. And so that was an enormous problem. I think that in terms of, since the full reopening guidance and the big push from the government to get everyone back to school has happened, that problem has reduced but it's not gone away. So there are no longer risk assessments in relation to individual students to determine whether or not they should be attending or not. That's gone. But we are still hearing of schools saying to particularly high needs students that it's too high risk for you to attend, and or we can't manage your needs, maybe because it's a person that requires suctioning or something that's very involved, and the school is concerned about the risk around that. Now that's quite at odds with the guidance as it is currently in place, but it is still happening. I don't have figures on that specifically. I think Special Needs Jungle, which is a really great resource. It's a website online that's sort of parent and family facing for people who are navigating what they call the special needs jungle in relation to their children trying to get provision, did do a survey during the pandemic, and some of those results, which are available on that website, did address the number of people who were not involved in risk assessments when they ought to have been, for example. So that was a big problem. We're hoping it's resolving, but there are still difficulties, and certainly as I think the local lockdown situation is evolving, I would expect this to be a continuing issue. I think you're on mute, Charlotte.
Sorry, thank you. I have a technical question from Ashley and O'Regan. Are you happy to make the slides available when we also record the question?
Fine.
Okay, that's most kind. Continuing then with the questions. Seamus Byrne from the University of Liverpool, hi, says that I think we're all aware that the health and social care provision outside education for children with SEND has been very poor for many during the lockdown. And with the regressive impact that that has had on the children, to what extent do you think we can start enforcing local authorities to carry out expedited reviews of the EHC plans, I think to try to account for the impact and to try and mitigate some of that impact through educational input?
Yeah, I think that's really difficult because one of the big concerns that there was about particularly the amendment regulations and the kind of extension of timeframes that were in place until late September was that this would create a backlog of cases. So effectively, before you had strict timescales, which said you had to take X step by this time, and so on, and that local authorities were being given the chance to sort of stretch those things out in circumstances where they were already consistently failing to meet deadlines. We are expecting there, given that, to be a massive backlog, and the delays that already existed prior to the pandemic in ensuring reviews are carried out are likely to be more significant. Now that's kind of just a logical deduction rather than based on any evidence that I've seen. Obviously, if a child is due for an annual review, you have a sort of a statutory deadline within which an annual review has to take place. So they ought to be sort of front of the line. In terms of triggering a review outside of the annual review process, you can make a request for that, but I imagine that there are going to be fairly significant delays in that regard. You might want to think about, if it's social care provision, for example, if you could show social care provision was a duty on the local authority to make under some of the legislation, which is again another sort of area of law to go into, it might be quicker and more effective to sort of go down a judicial review route to say that outside of the education, health and care plan context, you have a duty to make this provision and you failed to do so. That's just for social care. Obviously the healthcare provision is sort of is a different issue, but I think what's worth keeping in mind is that education, health and care plans sit within a broader context of social care and healthcare provision. And that there are other levers that exist if the EHCP process itself is somewhat stalled. I'm personally not very optimistic about things kind of picking up and being able to respond to the unfortunately quite significant effects of the pandemic.
I'm going to take two questions, if I may now, because I think they both touch on quite broad public law issues. Linda says, how are you going to be able to enforce the statutory timescales that were not in place during the Coronavirus Act, given that it was legal under that act? the coronavirus notices have now expired, the original timescales are in place, but, and I think you found this within your case perhaps to an extent, is there any public law basis on which you can challenge timescales that were not met whilst the Coronavirus Act notice was in place? And another public law question from Diego is, what paths do you see for the future operationalization of the duty to consult in judicial proceedings and policy makings? That's both touch on public law, perhaps.
I do, yeah. So I think two things. So for the period of time that the changes to the timeframes were in place, I just think it would be incredibly difficult to bring a successful challenge because of the level of deference to a local authority in terms of what was reasonably practicable. Now that time is running, there are obviously sort of transitional questions about, you know, how do we start if we were halfway through a process when things stopped, what happens? And there is some sort of guidance on that. But now that the timeframes are back in place, so for example, if tomorrow I had a client who made a request for an assessment for an educational health and care plan or a needs assessment, and the local authority didn't comply with that time frame, as things stand, the duty is currently an absolute one to have done so in a particular time, and so you would be back to regular judicial review principles of a failure to meet a statutory duty as set out in the regulations. So we've kind of snapped back to the kind of more conventional thing, sort of conventional approach. And it wouldn't be appropriate for a local authority to say, oh, about pandemic backlog now in relation to any delays, because the duty is absolute and there's no wriggle room, there's no concept of reasonableness left in it. The reality on the ground in terms of getting local authorities to do anything, it's pretty dire if you're having to issue judicial review proceedings to try to get them on the move. But that is what we're doing in relation to some clients to try to get the ball rolling again. I hope I've understood the question correctly and that covers that off. In terms of consultation, I think it's a really interesting area if you're a bit of a law geek. So if you're interested, there's a case called Plantagenet, which has sort of sets out the kind of various categories in which a duty to consult can arise. And the fourth category of Plantagenet is what we call as conspicuous unfairness category. And the other case that we relied on in the judgment, which you'll see, in the case which you'll see referred to in the judgment, is the Bart-Murphy case, which talks about the removal of a pre-existing benefit and when that might lead to a duty to consult. We weren't successful in our argument, and I think generally speaking, people see Plantagenet 4 as a fairly difficult category to establish. But I do think it's an area that's interesting. And so, for example, I don't know how they're going to run it, but you might have seen in the news recently that the university union, staff union, was bringing a challenge, or had at least written a pre-action letter in relation to the decision of the government to reopen unis for face-to-face teaching, despite sage advice saying the opposite. And one of the things they're arguing is that there's a duty to consult. There was a duty to consult about that. Now, I've seen the pre-action letter and it's not really developed on a legal basis, but I doubt that they'll be in any other category but Plantagenet 4. So watch that space to see whether they managed to make any inroads showing that there was a duty to consult there. Similarly, if you're interested, the Article 39 case about the kind of wholesale downgrading of various duties to children who are in care and duties in relation to adopting and fostering and so forth. That case did go up to the Court of Appeal, and the one issue that was being argued was duty to consult. And specifically in that case, it narrowed quite far to this question of whether or not there was a duty to consult the Children's Commissioner if there wasn't a duty to consult anybody else. So that might be another avenue that's explored, that maybe it's not a wholesale consultation that's required, but perhaps where you have somebody like the Children's Commissioner and you have a change that's obviously going to impact on children, if you don't consult the Children's Commissioner, you might be in trouble. We're still waiting for that judgment to be handed down, so that's another one to watch. But I think for claimant lawyers, where you have to kind of be creative and push at the boundaries of the law sometimes to try to get somewhere, consultation's an interesting one where we'll keep trying.
Okay, thank you very much. I think if it's okay with you, Alice, we may just run till 1:45, which gives us about another 10 minutes. A question from Mayombe regarding schools that have refused to allow SEND children to attend school, despite their parents' wishes to do so. Would it be far-fetched to invoke the ECHR right to education and argue that the school is in violation of that because they refuse to have the children back to school? Sorry, just simply before you answer that, we probably have time for about one more question, if anyone wants to race for one more question.
Sure. Yeah, I mean, I think that's interesting. So I must admit to not being intimately familiar with the jurisprudence surrounding Article 2, Protocol number 1. I do think that my gut reaction is the difficulty with anything like this is that I think we must accept that schools and the government have a level of discretion as to how to manage return to school in the context of a pandemic. And the willingness of a court to say you've exercised that discretion unlawfully, to my mind, is likely to be limited. I think the right to education stuff is interesting because obviously you don't have a right to specific education. So you don't have a right to, for example, to go to university, but once a state offers university, it must be provided in a non-discriminatory fashion. So I do wonder if a more promising route might be to say, well, it's not necessarily an outright breach of any kind of right to education or right to respect for parental wishes, but that this is a discriminatory practice that can't be justified by reference to the underlying circumstances of the pandemic. So we've got an Article 14 when read together with the right to education kind of argument. That seems more likely to me to have legs. What you then get into, obviously, when it comes to sort of discrimination claims is whether there is a sort of a adequate justification for the differential treatment. And again, I think that's where you get into difficulty as to how willing courts are going to be to scrutinise decision-making of individual schools as to whether or not a child should be allowed to return. And I would expect they might be fairly differential, but I don't know. I imagine there might be a case where a school has adopted, for example, a blanket policy, which they shouldn't be doing, and have said, no, we're not taking anybody who falls into these categories back at all without any kind of tailored risk assessment, where I think you could probably say that's not a justifiable approach. But I would have thought a discrimination angle would be likely to be more effective, but I'm very much shooting from the hip here.
I don't see another question, so I'll ask one if I may.
Sure.
It's a simple one. What is the legal aid situation for this? Because my understanding was that parents no longer had access to legal aid for taking cases to tribunal on the perhaps spurious basis that tribunals were set up for lay people, even if it is the practice that local authorities almost inevitably will bring a lawyer. So I suppose I might ask personally how you deal with that, and also more generally in the context of criticism to the failure to provide legal aid to parents going to tribunal on this and other educational matters.
Yeah, I think it's a massive issue. So if we're in the JR territory, we can get legal aid. So if you're just trying to say, well, you failed to make provision or you've not complied with the timescale, that's judicial review. But everything else, as you've pointed out, that goes to tribunal is not legally aided. So if you're challenging a decision whether or not to issue an education, health and care plan at all, or the content of that education, health and care plan, or the decision of a local authority to cease to maintain an education, health and care plan, all of that goes to tribunal, and parents don't have legal aid for that. There are a number of really excellent charities that provide support, IPSIA and so forth, but it's really not filling the gap. And I think what strikes me as an individual, so I do some of those cases pro bono, and I do some cases representing families before the tribunal on what we call a direct access basis. So we don't have a solicitor because that would add a layer of cost, and generally speaking, families can navigate tribunal system themselves in terms of sending documents in and emails, but then I do the advocacy at the tribunal, and so that's meant to keep costs down, but it's still expensive. What I find in dealing with families, unfortunately, and what you say about in terms of it just being, you know, this false idea that they can navigate the tribunal system on their own, is most of these families have been failed by local authorities systematically for a very, very long time, and there's a long history to the case, and there's a huge amount of ill feeling, quite understandably, and it can be quite difficult for an individual who deeply cares for their child in the middle of all of that to see the wood for the trees when it comes to picking out what the tribunal needs to hear and what is going to persuade the tribunal in relation to the specific issues that are being argued. So quite often we'll be saying, okay, we want to change section B, we want to say that the child's needs are X, Y, Z, and those, you know, those things aren't adequately reflected currently in the plan. And then that has the knock-on effect that the provision they should have named in section F is X, Y, Z, then that might have the knock-on effect that it's not appropriate for them to be in the school that's been named by the local authority. You want to be fairly focused and systematic to make those points, and that's really, really hard, I think, even for the most remarkable of parents to do when they're so emotionally involved and when there's such a long history. So I think it's an enormous problem and an enormous gap. Direct access work is rewarding and incredibly tiring because the kind of emotional toll that these cases take on these families, it can't be underestimated, and you're constantly dealing with very, very high levels of anxiety, and I do just think that having a lawyer available to them to make those representations makes an enormous difference in terms of outcome. Without wanting to blow my own horn, this is something that, just having somebody there to order the thoughts and to focus on what the tribunal will be interested in does a world of good. It's not a very formal tribunal, and it's not full of sort of fancy rhetoric, but it's incredibly important. And I do think it's a massive issue in terms of families being able to access the support they deserve and are entitled to.
Thank you. We've just had a very helpful comment from Linda Ewan that there have recently been some awards of exceptional case funding by the Legal Aid Authority for representation in the SEND tribunal.
Yeah, that's really a really good point, Linda. And so I don't know if anybody, I'm not sure who the audience would be, but if there is anybody watching who is personally affected by this, there is this concept of exceptional case funding that is available, and Public Law Project, and in particular a gentleman called Oliver Percy at Public Law Project, does a lot of work on exceptional case funding. And so if anybody's looking to try to access that to get legal aid for a SEND tribunal, that they would be somebody that would be good to contact to try to get assistance on that front. But that's, it's good that it's happening in some cases, but it can be fairly difficult to secure. And it's certainly no substitute for automatic funding for anybody who needs to take their local authority to tribunal, to secure the provision for their children. But yeah, thank you, Linda.
I'm going to thank you very much, Alice, indeed. And we have perhaps 2 minutes left. So rather than me continue to thank you, things are changing very rapidly. We're looking perhaps at we're looking almost inevitably at a second wave. I wonder if in 2 minutes you have thoughts, Alice, to put you on the spot rather, I'm afraid, about what we may be seeing in the next 6 months. And then I leave it to you to close this webinar.
Goodness. Much of the same, unfortunately. I would imagine that the system that's already broken will continue to fail families, and that we will continue to have to bring actions either to the tribunal or through JR. I think the big one to look out for, as I flagged earlier, is whether or not any local notices will be put in place downgrading that Section 42 duty. I think if things get worse, that might very much be on the cards, and that will be something that we'll be scrutinising, and the sector will be scrutinising very, very closely. But beyond that, goodness, who knows? But thank you for the opportunity to speak, and I'm sure that I do hope that you follow the developments, and particularly the Article 39 case, and I can commend that to you as something that you might be interested in. That's not specifically about children with disabilities, but would also be of interest to this group and those who attend, generally speaking. But yeah, thank you so much for the opportunity to speak, and Bye.